The last panel of the morning, which is really the complement to the one we just heard, is the second half of the NLRB and the DOL, and really is the key questions. Who's an employer? Who is an employee? If you read the National Labor Relations Act, there's a definition of employer. There is no definition of employee, which either means that it was believed by Congress to be self-apparent in 1935, or else they couldn't agree on it and decided to kick it down the road. And I think people have been trying to fill in those blanks for the last, as Paul said, almost 90 years. And as the nature of work and the workplace has evolved, I think the idea of what we would think of as an employee has also evolved with it. The panel this morning includes Michael Gray from Jones Day, who is the co-leader of the global labor and was the co-leader of the global labor and employment practice. He's now the co-client affairs partner. I'm not sure what that is, but it sounds important.
It means I've graduated from labor and employment.
Uh-oh.
Yeah.
I think everything after this is a demotion.
Indeed.
Professor Jonathan Harris from Loyola Law School, who teaches labor, employment, and contracts. I'm sure the labor and employment is the much more interesting part. You have to get through first year. He's the chair of the American Association of Law Schools section on labor and relations and employment law. And like many people here, he began his career arc in this field working in the field. He was an organizer before he went to law school and either lost the light or saw it. The commentator for this section is Wilma Liebman, who you can never ask for a better person in this role, former chair of the NLRB, literally served on the board from 97 to 2011. Is quite an accomplishment in both Democratic and Republican administrations. She's worked in labor law her entire career at the NLRB, at the FMCS. She, I know, has served as labor counsel for the bricklayers and allied craftsmen, counsel to the Teamsters, and chief external ethics officer for the UAW from 2020 to 2023. Enough with my talking about the accomplishments. It's all on the paper. Thank you.
Thank you very much. It's also been my pleasure for some years now to teach labor law at NYU, but the basic labor law class, and also a class that I co-taught with Cynthia Estlund for about 3 years, a seminar on the subject of regulating work beyond employment, certainly relevant to this. And as I just told Sam Estreicher, I'm not going to let him take all the credit for Peter Rawlings. Peter took my labor law class last year and was a star. So we don't have a whole lot of time, but our task is to look at this question of who's an employee and who is the employer under both the National Labor Relations Act and under the Department of Labor rules. Certainly the question of whether a worker is an employee or independent contractor, excluded under the 1947 Taft-Hartley amendments, the question whether under the NLRA or any other workplace law has always been a complicated question. In the US, the determination is binary. You're either an employee or an independent contractor. We don't have an intermediate classification, as some countries do, like Canada, the dependent contractor, in Great Britain, the worker classification. And some have say that these are fairly conflicting views, but most of the legal battles turn on the gray areas. In 1946, the Supreme Court decided the Hearst case and said then very presciently that few problems in the law have given greater variety of application and conflict in results than the cases arising in the borderland between what is clearly an employer-employee relationship and what is clearly one of independent entrepreneurial dealing. And the court talked about this very difficult issue in our very complex economy. That was 1946. They had no idea what our complex economy was going to look like today. It is very hard to get good data on the size and composition of the independent contractor workforce. They're kind of elusive. But I think current estimates from most recent surveys look at about 15%. Some people would probably say higher. The risk of misclassification is high, particularly amongst low-wage workers. And once the very difficult issue of employee status is established, there remains also the related and sometimes thorny question of which entity or entities is the employer. This is an issue of growing significance with changing employment models, changing business models, so-called fissured workplace, the end of what was once known as the vertically integrated corporation, and greater use of intermediary staffing agencies, outsourcing arrangements, insourcing arrangements, and of course, the issue of franchising. No issue brought to light the exclusions of independent contractors more than the Uber phenomenon. I remember a number of years ago, someone in the Silicon Valley said that Uber had made everyone in the Silicon Valley a labor lawyer. And no issue, I guess, has highlighted the who's the employer question more than McDonald's, and the lengthy litigation that was ultimately settled without resolution of the issue of whether McDonald's was a joint employer with its franchisees. These cases arising out of the Fight for 15, which began in 2012. These issues have flip-flopped a lot, depending on who's in the White House. And as I always say, it is absolutely impossible to talk about labor law divorced from politics. So, Michael, I'll turn to you. Do you want to talk about the recent flip-flopping on these issues?
Sure, Wilma, and thank you for having me, to you and Sam and the rest. I think Paul had it right in the last panel, and then Steve just talked about it. All of this really comes down to sort of the failures in our country to really legislate and bring the current legislation to sort of match the workplace. Not only did Paul mention, nearly 90 years from the NLRA, but we've got the Fair Labor Standards Act, which came just a couple years thereafter, which, just to remind everybody, defined an employee as one who is employed by an employer. I always love going that because you just really can't make that up, right? And then you wonder why for the next 90 years, right, we've been debating that as the workplace has changed, and other countries have decided to go a different route and, away from the sort of binary approach. The flip-flopping continues, as Wilma said, not only depending on who's in the White House, which, as Sam taught me many years ago, we see at the board, but now we see it in the courts as well. So it's really just compounded, not just the issuance of new rules and rulemaking and the rescission of rules depending on who's in the White House, but also in the courts and where it's being adjudicated. When you look at where all of these issues, the proponents of one side or another are selectively choosing their circuit and their district court, and now often the division within the district court. You'll see why it is so many decisions are coming out of not just the Eastern District of Texas, but one courthouse in the Tyler Division in the Eastern District of Texas, where there are two judges sitting that those people who are sort of against what they see as sort of administrative encroachment are filing, right? Then at the same time when in the Trump era rule involving independent contractor, when that was challenged, that went to the Southern District of New York. So, I mean, as Wilma talks about flip-flopping, it has really just sort of increased in magnitude, not just from the back and forth of the board, which was done by design, but within our courts, and perhaps not an observation of precedence as we were all taught in law school. A couple other points on that. So much of this comes back to sort of two critical issues that I just thought are worth mentioning before we dig in. So the independent contractor that Wilma mentioned really comes down to whether or not the traditional tests should emphasize sort of the entrepreneurial opportunity or the opportunity for profit by the contractor. And the more conservative and Republican approach has been to focus on that whether that occurs in litigation or in the rulemaking. And then that has been pushed back from a more traditional test that came from the restatement that looked at a number of factors and without an emphasis. And so that has flip-flopped back and forth, whether it's at the board with FedEx 1 and FedEx 2 going back. I mean, we've been talking about this, I think, Sam, since you put this this fantastic conference together back in FedEx 1 in 2009. Depending on where you're sitting, whether it's at the board or at the DC Circuit, there's been a battle of whether or not the court should look at this sort of entrepreneurial component and provide more weight. The Department of Labor under President Trump tried to follow that approach as well, which was rejected in the Southern District. So currently we're sort of back to square one with respect to the independent contractor and whether or not it's the traditional agency test that goes back to the restatement in the 50s. And I think most of the courts, if you look at the courts, Wilma, state and federal, have really sort of ignored a lot of what the Department of Labor and the board are saying and really are looking at more traditional tests in the particular district or circuit or state that they're looking at. On the joint employer, it's been much of the same. This goes back to under the board test. We all know we've been talking about this since the original Browning-Ferris in 1982, and depending on what year we're here, what administration, or what's the sort of composition, of the DC Circuit. We've had Browning-Ferris 1, Ferris 2, Ferris 3, depending on how you're counting, and the back and forth, which is just making it particularly difficult on whether or not, and the core issue, whether we're talking about in front of the board or the Department of Labor, is whether or not there's actual control, the way we were talked of the sort of essential terms and conditions of one employer over another, or whether or not there is the ability to control or reserve control or authority to control. And that has been the battle that is sort of thematically flipping back and forth. One could argue that courts have been looking at whether or not there is the authority to control from the beginning, but if you look at the case law, that's not where the decisions have been coming at least in the last 40 years. So that battle is back and forth. Depends on where we're talking about, if we're at the district court or at the DC Circuit. We have competing cases currently at the DC Circuit as well as in the Fifth Circuit. Really none of it is providing us much comfort or much clarity, and the same under the Fair Labor Standards Act as well. So that also sits in two different places. So the long and the short of it is that was probably longer than you had in mind, but the flip-flopping continues, and it really depends. And I would say, as a person who spends a lot of time working with large employers in this country, it gets very difficult to sort of get your compensation schemes, get your structures right, get the benefits correct when you don't understand where the law is or what's going to be happening in the near future.
Yeah, I should have mentioned earlier that employee status is defined differently under the different workplace laws, and they go from the narrowest test for employee status, which is the common law test, sometimes called master-servant, which I think is quite an oddity in the 21st century to be talking about master-servant. But that's the common law test. That's the narrow test under the National Labor Relations Act. I think the IRS uses the same test. To the broadest test, which is the economic realities test under the Fair Labor Standards Act, or otherwise known as the suffer and permit. But these are all multi-factor tests. There's also the ABC test, which has been used in some states, and that has become an issue in the state of California. As Michael mentioned, some of the states are branching out and doing things on their own on this issue. Just to give you a sense of the NLRB joint employer rule, it's true that first the board went all around in circles over the decision they issued in a case called Browning-Ferris, and then Highbrand, I think it was called. And then there was a joint employer rule issued by the Trump administration. The Biden administration rescinded that, issued its own rule. That was struck down in March 2024 in the district court in, guess where, Texas, pending on appeal. In April of last month, the Senate approved a measure to block the NLRB joint employer rule by a 50 to 48 vote under the Congressional Review Act. President Biden vetoed that resolution in May 2024. Two-thirds majority in the House and Senate would be needed to overturn it. That's probably unlikely. So I don't know what happens at this point with the Fifth Circuit. Maybe Jonathan can enlighten us. I think he clerked on the Fifth Circuit. But I want to turn for a bit. We don't have a whole lot of time. So rather than dig real deeply into the legal standards that are governing per se, we want to take a look at the implications for these issues in the broader economy. So first, let's turn to the gig economy. I already alluded to that with Uber. And the issue of the independent contractor status. So Jonathan, what do you see the impact of these expanded definitions, DOL and NLRB, on gig economy workers and perhaps even their possibilities for collective bargaining and workplace coverage?
Yeah, well, there are two issues that I think are particularly interesting with this. One is the organizing strategies of unions. And the second is whether we might see a trend toward reclassification of workers as employees, or what could happen with that. So on the first one, on organizing strategies, it's interesting because some unions are actually starting to try to create a structure for collective bargaining without having workers formally designated as employees. Or in other words, getting into this fight over employee versus independent contractor status. This is especially playing out in Massachusetts. So there are two different ballot initiatives that will be on the November 2024 ballot. One sponsored by the rideshare companies, Uber and Lyft and others, to formally classify them, rideshare drivers, as independent contractors in the way that we saw in California, where I am, with Prop 22. There's another one that's actually sponsored by SEIU 32BJ. I think it has the support of the Machinists Union as well, that would give collective bargaining rights to rideshare drivers and completely skirts the issue of employee versus independent contractor status. But there are other unions that are really holding firm to the idea that they should be classified first and foremost as employees. So it's interesting to see how that might play out. In addition to Massachusetts, there's an ongoing Attorney General's misclassification suit happening that'll be going to trial this summer, and separate Massachusetts legislation to make gig workers formal employees. In addition, there are, like I mentioned, the Uber ballot initiative in Massachusetts. This is something we've already seen in California. As a matter of fact, the oral arguments were yesterday in the California Supreme Court over the constitutionality of that Prop 22 ballot initiative that the voters of California voted in favor of to make rideshare drivers independent contractors. It sounds like from the initial take on it that the Supreme Court might uphold that ballot initiative, maybe with a carve-out for workers' comp issues. So that's all going on. One thing that I've thought about, this might lead to more discussion of a third category. Canada has this third category called dependent contractors, which is somewhere between employee and independent contractor. As it relates to bargaining rights, there was a case in 2020 from the Ontario Labor Relations Board called Foodora that actually determined that gig workers had the right to collectively bargain, even though they were classified in this kind of nebulous middle category of dependent contractor. The other issue I mentioned that I think is interesting is whether companies might think about reclassifying workers as employees, given all of the scrutiny around this. It's interesting because companies have to maintain this tricky balance between having enough control over their labor force to preserve how they want things to be done, while also giving them enough independence to credibly classify them as independent contractors. There has been at least one instance of a company going back to classifying as employees. It's called, there's Deliv, which is a company in California, after the state legislature passed AB 5, which has established the ABC test, very much in favor of employee status, decided to make them employees again, although that might still be a little bit murky. So I think this will be interesting to see if we might see a trend. One other thing I want to mention was just antitrust implications of independent contractor organizing. Professor Estreicher and Jack Samuel have a forthcoming Wake Forest Law Review article about this issue, where they argue that antitrust laws don't prevent gig workers from organizing unions. So there's that too, but I think that's those other two things I mentioned should be interesting. AB 5 is still the law. Yeah, so AB 5 is still the law. The ABC test is still the law in California, and it applies to all workers. Prop 22, the ballot initiative, only applies to rideshare drivers. And so for all other workers, AB 5 is the controlling law.
I do have a question, Jonathan. There's a case that in the employment context that we talk about all the time, the old Martinez case in California. And I'm curious on because of the dependent contractor, if we could actually get some type of legislation here, or anyone on both sides of the aisle to agree on anything, where in that case, it involves strawberry workers, and they all work for a company that had one client. The client terminated the contract, therefore the employer terminated all the strawberry workers. There's no doubt in that, and that's been a law that we've been debating in joint employer cases since I started in 2000, I think, one on that. Would if we had this for sort of dependent contractors, would that change the Martinez sort of framework? Because there's no doubt that all of those folks were dependent on the purchaser, the ultimate purchaser of those strawberries. I'm just curious, because I think that would be an elegant solution. I'm just curious how that would work in that context.
Yeah, well, I don't know the answer to that, because the idea with dependent contractor status, as I understand it in Canada, for example, is that it recognizes the fact, and actually that's one of the most important factors, is are they dependent on only one company for the vast majority of their work, which is
And in that real life example,
Right.
they were. There
Right.
was one. And so when the employer lost that contract and terminated everybody, the question was, did they have rights against the ultimate sort of strawberry purchaser?
Right.
Anyway, I just think it's interesting because that has always been, even in a state like California, as they used it in the ABC test, that still remains very good law.
Yeah.
And that theory, that new principle would change that, which
Right.
would make very difficult, I think, to operate. If the strawberry purchaser somehow was responsible for the rights of the employees to which they had no direct relationship.
Well, and I think that also kind of brings us to our next issue too, on joint employment, when these vertical relationships between the companies.
Yeah, shall we turn to joint employer then?
Sure.
So what do you think, either one of you first, are the implications of a broader joint employer test that takes into account the actual and reserve control and the direct and indirect control? What do you think the implications are in terms of franchisor liability for unlawful conduct, franchisor duty to bargain with employees of the franchisees, and in terms of the practices of outsourcing, insourcing, and the responsibilities of the lead firm for the employees of the subcontractors?
Always a whopper there.
Yeah.
That's a whopper.
And then let me add in supply chain
Oh,
accountability.
we'll throw that in there. I'll let Jonathan cover that. There is no doubt, Wilma, that if the test becomes, and by the way, the Fourth Circuit has sort of moved towards this. They're the only circuit to do it. But there's no doubt that if the test becomes the sort of right to control, the reserved authority, depending on whether or not you're looking at it in what context, it does change really the entire framework of the franchisor-franchisee relationship, and the way employees, and who they're employed by. So this really goes to what is the sort of respective leverage of this, and does, for example, in Wilma's example, does the franchisor, the hotel company, for example, have ability to sort of control or make certain decisions with respect to the employees of the franchisee? There is one key distinction, I think, in there, where we've seen sort of the cases, and some of the judges, I think, get too far ahead. Even if there is sort of reserve authority or the right to control, we have to look at what is that, the controlling of what, right? Because some of these cases, including in the ones that you've talked about, it's not just the reserve authority to control traditional sort of essential terms and conditions of employment, which I think is manageable. If the law was to go to that, I think companies could do it. But if it's the right to control, frankly, anything that has perhaps an indirect control, like you're well aware of, in some of the cases, it's the music being played, or the colors being used, or the hours that they're being opened, or the services being provided that don't relate directly to the terms and conditions, that would get very difficult, I think, to operate in. So I think short answer is, one, I think that would be a dramatic change to the way, and companies would have to consider restructuring the way they provide opportunities and employ workers, and we could have a separate argument about, what's that?
Are there decisions that go that far?
There are, and the Fourth Circuit starts to look at it that way, and then there were cases, yeah.
There's one case.
The Salinas case in the Fourth Circuit starts,
Is a franchising case?
Salinas is a no, I don't think it's a
Probably not.
franchisor case, no.
I don't know if there've been any.
Held that, I call it the user employer, in this case, the other employer, the other company, whatever, they were held to be joint employers of the employees.
Yeah, they're looking at the relationship between the putative employer and
Yes.
the other employer in
Right.
Salinas, yes.
And as long as they have the contractual right to control everything, they are also responsible for the actions, well, actions of the employees of the clear employer.
Yeah,
right?
no, I think so.
Sam, if you're going to talk, you should come up here and use the mic.
Come on,
Otherwise, let us do the talking.
It's Hoj,
I like to
Sam.
be an ambulatory.
I know.
Yeah,
But
well,
but
more
I-
dry dock picketing then.
Or dry dock.
Yeah. So what about Jonathan? You want to comment
Yeah.
on this joint employer issue? We're running out of time.
Sure, yeah,
I don't know what he said. It's not important.
something about dry dock. Yeah.
There's no one here but me who can talk back to him.
I mean, just briefly, I think this might be another one of those things where we might see companies thinking twice about the whole franchise model. I mean, my understanding of the history of franchising is, especially in the janitorial industry, is one of the areas that's become very popular. It didn't start until the 1970s or so, when this company, I think it was called Jani King, decided that they wanted to try out this franchising model because up till then, all of their commercial janitors were their employees. And that's kind of where it came from. And so it's a relatively new thing, and I think that, again, it gets to this tricky balance that the companies have to figure out between having enough control over their labor force to make sure that their brand is adequately represented, and at the same time, again, giving enough independence to credibly claim that they're, in this case, independent contractors or franchisees. As it relates to offshoring and outsourcing, I mean, we've already seen so many companies rethink that since the pandemic, right? When we had the huge supply chain disruption and no one could figure out how to get our parts. And so I think that's related to this too. On the other end, as it relates to labor practices, recently we've seen more scrutiny on labor supply chain practices. I remember, for example, when I was a college student in the late 1990s, there was a big campaign around labor conditions and supply chains, especially around university apparel, and groups like the United Students Against Sweatshops were organizing around this. And so maybe this is something that's coming back a little bit as well.
I would have to say, Jonathan, I do think in the franchisor or franchisee, unless there's legislation, I don't think we're going to be moving away from that. One could argue there are certain efficiencies. It does promote extraordinary growth of small business. it is good for the country's middle class, et cetera, where you're having, many more employers, many more opportunities. There's competing, I think, academic research on whether or not the net growth of jobs is impacted, but there's some pretty thoughtful folks out there that are suggesting that there is a sort of a net positive impact to sort of that model, despite, by the way, Wilma mentioned it in her original comments about Dr. David Weil, and when he started talking about the fissured workplace, there is no doubt that that is fissured, but one could argue, and very smart people have, that it's really been great for workers. It has not been good for unions. There's no doubt about that. But I'm not so sure without legislation that we're going to see sort of a change in the franchise model.
Well, I mean, I don't doubt that it doesn't work in all conditions, but I've also seen some situations where it's very, very exploitative. And in the end of the day, it might be an issue of being forced to change, depending on how things go with the legislative landscape.
There are also some franchisee organizations that have formed to get better power and control from the franchisors.
And some, by the way, Wilma, have gotten awfully large, like the largest restaurant, hotel franchisees. These are massive.
They're massive.
They're massive companies right now. They are, I mean, they have thousands of restaurants, and so the traditional dynamic has changed from the historical, when it first got started, where it was sort of ones and twos, to really a whole business where franchisees of major brands are extraordinarily large corporates in their own right.
And, I remember a conversation with David Weil when he was wage and hour administrator. And he said that the joint employer argument would be harder to make in a franchising situation than in a contracting out or outsourcing situation. And that's because the franchisors have a wide range of structure. From some tight control to very little control. And certainly, if they want to avoid joint employer determinations, they can structure them, get very hands-off kinds of arrangements. But I also remember when the Obama board first issued the Browning-Ferris joint employer test, I spoke with someone who was a high official in one of the hotel chains, and he said the decision caused them to do an in-house assessment of their contracting out arrangements. And it was kind of shocking how much these hotels actually contracted out. And they said, if we're going to be held liable, we probably should take some of this work in-house because there are sometimes immigration violations with some of the lower contractors as well. He said some things we won't take in-house, like landscaping, but housekeeping and other things we might. So I think Jonathan's point perhaps applies mostly there.
If I can add, I'm sorry.
Go ahead.
Just to add one more point, Roger King has often made it, he's here. The franchisor has to care about certain things. Now, we don't want the franchisor having effective control over most labor issues, because then they're an employer. But, they have to care about certain things. For example, there are certain HR issues that require that the franchisee take responsibility in certain circumstances that shouldn't count towards joint employer status.
Well, that, Sam, I think is the balance that Jonathan's talking about. It's like, how do you make sure you have basic protections in there, but not sort of cross the line?
I agree.
And as Wilma's saying, I think that some good has come out of all of this, where trying to make sure that basic sort of immigration controls, by the way, the procurement function at these, making sure that there are appropriate subcontractors, et cetera.
Wage theft at the bottom.
Wage theft, et cetera.
Yeah.
So I think there is some good, but I would argue that there's a line, at base, the franchise model is best for the economy and best for workers, but that's a much more controversial position.
So we have a limited amount of time left. We wanted to turn to one, if not two other things. The one I'm not so sure about, because Michael said he didn't really follow it closely, was there's another aspect to the employee status issue. And that's something that the prior panel said they were going to get to but didn't, which is the college athlete. And the question of whether they are employees under the National Labor Relations Act and entitled to bargaining.
Sorry?
As you may know, the basketball players at Dartmouth College have voted to unionize. There's another case wending its way up the pipeline involving University of Southern California, football players and basketball players. The two are quite different, as I understand, than the facts. So Dartmouth, like most of the Ivy League, does not offer athletic scholarships. Dartmouth operates its basketball team at a substantial loss, financial loss. The USC makes several hundred million, or $187 million from its athletics. They do offer athletic scholarships. And as someone I know who's a professor at USC said recently, I've lost interest in USC athletics because they've become so pro-like. So, Michael, you can weigh in if you want, but I know Jonathan has some comments.
Yeah, I mean, this seems to be one of this case, it's going to go case by case. I don't see any other way around. I mean, Wilma already described two situations that sound pretty different. So, and, you know, we have the regional director of the NLRB already ruling in favor of employee status for the Dartmouth basketball players, getting appeal. We'll see where that goes. You know, the other implication of this are the NIL deals, name, image, and likeness. And so college athletes in elite sports are already getting paid, the famous ones, the ones that can get the deals. And I think that would be interesting to see how that affects, you know, desire to unionize as well.
Yeah, so the Dartmouth president announced that they're going to fight this issue, and I read that they've hired the same lawyers that SpaceX hired for their constitutional challenge to the NLRB. So one other area that I think Michael in particular wants to address, which is on April 24th, the Federal Trade Commission issued a final rule prohibiting employers from entering into or enforcing non-compete agreements with workers. It was intended to promote competition by banning non-competes nationwide, protecting the fundamental freedom of workers to change jobs, increasing innovation, and fostering new business formation. The rule broadly defines worker as including employees, independent contractors, externs, interns, volunteers, and apprentices, and sole proprietors. You want to?
Yeah, no. I think it's not the substance of it. That's a whole nother topic, right? About the use of non-competes. I think in the definition of who's covered is really where it's at. I think Jonathan has been posing this in some of his writings and research, is that in this situation, the FTC, and we heard from this last year, Sam, about where they were going at this conference. But what I think is most interesting is they're throwing out this, we're not going to battle of whether or not you're a contractor or an employee. We're just going to say worker, which really goes to where Jonathan thinks legislation may be going in our country going forward, right? So the FTC sort of said, okay, we're not going to get into this back and forth, the flip-flopping, Wilma, where you started, which you really can't get anything done because you get all tied up in the courts for decades, but we're just going to define it up front and then go from there. So I think that's really, not a lot has been written on this. Jonathan's written on it. But
A lot's been written about the FTC rule.
Correct.
And whether it will hold up.
Correct, but and that's true. But what I think is the idea, really the approach, Sam, that we're going to avoid this contractor versus employee is sort of relevant to what we're talking about, irrespective of whether or not
There are
the
contract
FTC.
and tort obligations that apply to non-employees, and non-employees can assert, you understand that?
Yeah.
Part of the general law, it doesn't require employment status. That's a good point.
So anyway, I just think that we'll start to see more of this. If you're going to try to affect change, let's try to get away from employer, employee, contractors, et
What do you
cetera.
What do you
Yeah,
think
I mean,
the
what I
effect of-
think is particularly interesting about this is just different agencies stepping in to regulate the workplace. It's not just the FTC, the CFPB is as well, when it comes to employers selling financial products to their workers, seeing those as products for personal, family, or household use, which gives the CFPB jurisdiction over those. So the FTC in Section 5 of the FTC Act is, in this case, applying its unfair methods of competition authority. I just wrote a Law and Political Economy blog post about this rule for non-competes and the legal challenges to it. And so the FTC is regulating the workplace as a labor market, not as formal employer-employee relations, as does the NLRB or the DOL. So the FTC can cover independent contractors, small business owners. They chose not to cover franchisees in this rule, although the FTC actually has its own separate franchisor rule that's been on the books for a long time around disclosure requirements that franchisors have to make for franchisees. And there's a long history of the FTC actually regulating the workplace and job training going back to the 1930s under both the Section 5 Unfair Methods of Competition and their Unfair and Deceptive Acts and Practices Authority.
Yeah, but the question is, do they have rulemaking here? Rulemaking
So
authority? And that
that's
is-
one of the main challenges
That's-
now.
there are a couple of challenges.
Yeah, I mean, so in this blog post I wrote, I argue with Sandeep Vaseesan at the Open Markets Institute that they do. Section 6G of the FTC Act clearly gives plenary authority to write rules, and we have a textualist, judiciary in many ways, and so that's, even if there's not the tradition of ruling in that way, that I think that's something there. The other thing, speaking
So what
of
is the
politics,
wisdom of banning non-competes across the board? The common law says they're presumptively prohibited. I understand there's some bad cases out there, and, bad employers create bad cases. There's no justification for having non-competes with low-wage workers, and our restatement of employment law recognizes there's a tort action there. But the justification, just sweeping across the board, irrespective of access to
well,
trade secrets.
yeah, I mean, that's the
I don't
idea
think-
with the FTC regulating here. They're
Right,
seeing it
right.
as a labor competition issue, and so they see, I guess, any non-compete as being against
They used
labor.
to see every union the same way. I mean, I don't think they have competence in this area of labor relations.
What's interesting to me is how these antitrust questions have crept back into this whole workplace.
other direction.
From the other direction, yes. And so they've been used in this situation to try to protect workers. They're certainly being used offensively also, so the Ninth Circuit had struck down the Seattle ordinance, the Uber ordinance, that provided collective bargaining to Uber drivers on antitrust grounds. Professor Estreicher has written that people like Uber drivers shouldn't be subjected, even if they're independent contractors, to
If you
antitrust.
provide only your labor services, your personal services, and you don't make a significant capital investment, you're a laborer under the statutory labor exemption.
But I think what's interesting about the FTC rule is that it might get more Republican support than one might think on its face because it's based on competition, first and foremost, which it means that unions are not all on board with it either.
That happens, I'm 5 feet 5 tall.
What's that?
If that happens, I've gained 3 or 4 inches in height.
All right. No, not to say that they're going to be 100% on board, but it might have a little bit more play there.
So
I get to pull the hook once again. Another interesting conversation that I think could go on for another hour, and I'd like to hear it. It is a little bit past 12:30. You did promise you'd get us back on time, and I think this panel's done a great job with it. Really interesting conversation.
Great job, and I want to thank Wilma and the other panelists, Michael Gray and